For those on the line, I'm Mark Benedict. I'm a partner in the insolvency group in Kansas City, and I'm sitting here in lovely Kansas City North for this presentation during the COVID crisis, our lunch and learns on insolvency and workout issues. Joining me here today for the presentation is Chris Rockers, also joining us from a Northland office in Kansas City. Chris is in the banking and finance group office in Kansas City. Chris, I think you're in financial services SBU, and I'm in the food and agribusiness SBU. But don't let our SBU designations limit what you think our capabilities are. As most of you, we practice cross SBU, cross office, and do work all over. Today we're going to be talking about UCC Sales, and I know that you previously had a WebEx lunch and learn on basic file review. But before we get into the nitty gritties of UCC Sales, we do have a few what I'll call ridiculous basics that we just want to hit just briefly. As a part of the file review that you would have done in this engagement for a client, you would have reviewed the security agreement. And as dumb as it sounds, before we can move on to a UCC sale, we need to make sure that we have a valid security agreement. So we put up on the screen a couple of bullets on the minimum requirements for a valid security agreement. That, of course, is that there must be a granting clause in the document that is a clear grant of a security interest. It must be a document that is signed or authenticated by the debtor. And as we move through our slides here today, the term debtor that we will use is the debtor on the security agreement, the one that has pledged the collateral. That may in fact be different than the borrower under the loan documents. The security agreement must describe the collateral, and ultimately the debtor must have rights in the collateral. The UCC concept is attachment of security interests, and the attachment occurs the later of the granting of the security interest in the security agreement, or the debtor acquiring rights in the collateral, whichever happens last. This point that I've listed in the green below is one that is, again, fairly basic, but ironically it comes up a lot with borrowers in litigation. You don't have to have a perfected security interest to enforce a security agreement. The security agreement gives you rights in the collateral vis-a-vis you and the debtor. And as such, you are entitled to enforce your UCC interest. The perfection is only a place in line and dictates your rights vis-a-vis third parties, and it really is an issue of priority. You can have an unperfected interest and exercise all the rights and remedies provided by the UCC. And so you will, in litigation scenarios, when you have a recalcitrant borrower or a recalcitrant debtor, they will raise this issue, the lack of perfection, as a reason why you cannot or should not have sold their collateral. As silly as it is, it's fairly easily dealt with, but it is an argument that comes up so far in every piece of litigation where I've had to litigate a sale. The borrowers made this argument that the lack of perfection prevented the lack of an ability to enforce the security agreement.
Yeah, Mark, just a couple of points on this slide before we move. And I want to just hit a couple of things. And as a transactional person, I'm here just to provide a little bit of color. And to make sure I keep Mark honest. But first of all, just as an administrative matter, if you have a question, I think you can click the little chat button and type it in. And if you want Mark or me or all of us to see it, you can make those choices when you ask your question. One of the things on the description of the collateral, and it has to be a collateral description that satisfies 9108. Which generally means that you have to describe your collateral by type or by other description. You can't do a generic description like you are allowed to do in a financing statement to perfect your security interest. The other thing too is if you are like Mark and you find yourself in the unfortunate position of needing to foreclose an unperfected security interest, You're still going to have to do the searches, and you're still going to have to notice up all of the filers that have filed. We'll talk about that a little bit later this afternoon. But you're probably going to find yourself not being able to, because you're not perfected. Those interests will continue as a priority interest would continue to prime you, and the collateral and any sale you make would be subject to those interests.
And again, the next slide is an absolutely basic concept, but there actually has to be a default, not just under the promissory note, but there has to be a default under the security agreement. Now, generally speaking, if there's a default under the note, there's a default under the security agreement, but that's not universally true. We have, on behalf of a client in the last 3 months, dealt with an issue where the security agreement limited the security interest to being paid upon a voluntary sale. So a default under the underlying debt instrument was not a default under that particular security agreement. And so you may have some unique situations, which again emphasizes the concept of loan review before moving forward with the sale process. The security agreement may have some additional defaults that you might want to note, and there may be some inconsistent cure obligations or cure rights as between the loan documents and then the security agreement. And we always recommend that you comply with the longest period of time for cure obligations and cure notices, just to avoid controversy. But assuming you have a default, the UCC is absolutely clear that after a default, the lender may dispose of the collateral in its present condition or following a commercially reasonable preparation. So this is, the gating issue on moving forward with a UCC sale.
Yeah, and there's this issue of defaults is something that we're hearing more and more about, obviously, just given what's going on with the economy. But I just dealt with a situation last week where the clients were saying they had a cross default, they had a standard list of defaults, and it cross defaults to other material indebtedness. They're particularly focused on a large credit facility that the debtor had. And the question was, if they default under the other facility, but cure it under that, and because we're cross defaulted, can we declare a default under our facility? And the answer is you cannot. It has to be an event of default, fully matured under the old to cross over to the new, which would then allow you to exercise remedies. But those sort of sciencing out those defaults is something that we end up doing a lot.
And it's substantial leverage by lenders if there are substantial cross default provisions, but unfortunately you have to jump through all the right hoops in the right sequence to connect the dots to get to the enforcement of the particular sale rights and the particular collateral you want to sell. But again, assuming we have a valid default, we have the right to dispose. The fundamental legal concept on all UCC sales is commercial reasonableness. And this is a direct quote from 9610B. I won't read it because we can all read it, but it affects every aspect of a sale. And such basic things as selecting an auctioneer to do a public auction. Does that auctioneer have experience with collateral of this type? If they don't, it might not be commercially reasonable. The location of the sale itself. If you've got equipment in the middle of Kansas, is it reasonable to sell in the middle of Kansas, or do you need to bring it to a larger metropolitan area? Where do you advertise? So often I see in these UCC sales, the advertisement is in the legal record of the city that you're in for legal publications, but it doesn't necessarily go out widely. And if it doesn't go out widely, that may be a commercial reasonableness issue. How long do you advertise? What is reasonable and what is sufficient for the particular type of collateral? Did you do target mailings? Were those target mailings to the right audience of potential buyers? All of these issues are issues of commercial reasonableness and can be attacked and criticized. In more complex sales, I have hired consultants to advise us on commercial reasonableness, because then you can go to the court and say, Judge, we didn't make all these decisions ourselves. We went to a consultant who was knowledgeable in this type of property, who advised us how the best way on an expeditious basis to sell the asset. And we relied on the recommendations of a third-party expert. Those things might be able to help insulate you on these decisions. But again, go ahead, Chris.
So, Mark, no, just a quick question. You know, one of the problems, and we'll get to this later, is the question of notice. Did you give the right notice? Did you give notice to the right people? And if you have a secondary obligor and you don't give notice, is that failure, a lack of, does that deem the sale to be not commercially reasonable, or is that another defense with a whole other set of remedies as a result of their failure to give notice?
Well, it could be both. If the secondary obligor is the person most likely to buy the asset at the highest price, it certainly could be phrased as a commercial reasonableness issue. But also, if you intend to extinguish the rights of the secondary obligor without giving notice, again, that's the second bundle of legal issues that you've identified. But no, I think that you end up with both. And I've pitched and argued these both as commercial reasonableness issues and as other statutory failures. The ironic thing is that the statute is really focused on the process. The question is fundamentally the reasonableness of the process, not necessarily the ultimate price. So if you run a completely commercially reasonable sale, but yet you get a crappy sale price, you may have a completely valid sale that is not subject to challenge under commercial reasonableness. It might just be that the property just isn't going to yield a good price. Now, is that to say price is irrelevant in the commercial reasonableness context? It is not. An unreasonably low sale price may be indicative of a commercially unreasonable process. It is not in and of itself definitive evidence of unreasonableness. Now, in the more, go ahead, Chris.
Well, I was going to say, Carrie just asked a question about how this changes, if at all, in the context of a receivership or bankruptcy sale. Now, my response to this, and Mark, you can correct me if I say this wrong, but generally, we're going to talk a little bit. Mark's going to have some forks in the road. One of those is judicial versus non-judicial. But a sale by a receiver or a sale by a bankruptcy court is not an Article 9 foreclosure sale. So those are subject to completely different rules, and so the commercial reasonableness determination just doesn't come into play in those contexts.
Which is not to say that the judge that's supervising the receivership or the bankruptcy isn't going to review what the receiver or the bankruptcy trustee or debtor in possession has proposed as their sale process to determine whether it is reasonable. And an unreasonable sale process is a common objection in those, but it is not, as Chris says, an Article 9 question. And if ultimately the judge approves that process of sale on the front end, the judge is going to approve the sale result that results from that process. I did, on commercial reasonableness, I think it's also important to understand that you can agree with the debtor after default what is commercially reasonable under the circumstances. In certain instances, you can agree pre-default of what would be a commercially reasonable sale process for the lender to follow. And so in terms of a drafting note, if you're on the transaction side like Chris is, if you have some fairly unique collateral and you want to prescribe the legal standards as long as they meet the minimum requirements of the UCC, the parties can define a reasonable sale on the exercise of remedies.
Yeah, and a good example of that is we do a lot of transactions to do floor plan financing, and the sort of the corollary to the inventory financing agreement with a dealer is a vendor agreement that provides some support by the seller of the inventory. One of the things that we always get in those deals is a repurchase agreement. We'll talk about this a little bit later also, but the repurchase by a vendor is a private foreclosure sale. And we always have in our inventory financing agreement a description that we may have a purchase arrangement to sell to a vendor, and we give some detail with respect to that, and we have an agreement within that document that transaction would be commercially reasonable.
And obviously that will be binding on the parties that sign the agreement. If there are some junior interest holders that haven't signed on to that particular item, they could raise the issue of commercial reasonableness, not be bound by the written agreement that's agreed to on the front end. The consequence of not conducting a commercially reasonable sale. In the old days, pre-2000s, there were courts that determined that you waived your entire deficiency balance if you did not conduct a commercially reasonable sale. That is no longer the rule. The rule is that the debtor gets credit on the sale for what a commercially reasonable sale would have yielded as a credit against the debt. And so if there is a sizable deficiency and a commercially reasonable sale would have only gotten maybe 50% of that deficiency covered, then the borrower, debtor, it still has a liability for that remaining 50% deficiency. Unfortunately, these types of situations are ripe for a battle of the experts. So when these actually go to litigation, the debtor is going to have an expert to present what they propose was a commercially reasonable sale and what the sale results would have been. And you, as the secured lender, will have to prove generally that everything was commercially reasonable and that your sale was objectively commercially reasonable, and oftentimes with an expert to come in and say this was a reasonable sale. Now, oftentimes your auctioneer or broker can also be qualified as an expert based on their experience to say that the process that they ran was reasonable. So you might not have to get an extra expert, so to speak, but it does ultimately require expert testimony and qualification of the witnesses as experts. Chris, anything on this before we move on?
Nope.
All right, here's the first fork in the road that Chris alluded to. When looking at sales, we have to decide, do we want to move with forward with a judicial sale or a non-judicial sale? This is kind of a gating issue before we start talking about the nuances and the technical requirements of a UCC sale. You got to decide whether you want to go in that bucket. And there are, a few instances where a judicial sale might be more palatable. However, most UCC sales are non-judicial, but a judicial sale ties in to the UCC as well. I've just put up a few for examples in my bullets here. Some states are very restrictive on the rights under Article 9. Louisiana is the poster child for this. You can't do self-help repossession, and they are very, very parochial about protecting the local parish sheriff who gets a commission for running these sales, for storing the collateral. And so in certain states, there may be some requirements based on the type of collateral to conduct a judicial sale. Sometimes you have a bust or an ambiguity in your document that you don't want to have vulnerability on after the fact. And so you'll want to jump through the hoops of a judicial sale. To Carrie's point, some buyers believe a bankruptcy sale or a receiver sale gives them better title because they have a court order that authorizes the sale to them. And so the buyer may demand the certainty of the judicial sale process. And you oftentimes, in a judicial process, can block subsequent challenges to the sale, which you don't have that ability in a non-judicial forum. Oftentimes, if you have mixed collateral that involves both real and personal property, most states require a judicial process. Those that don't, some of them have what are referred to as one-action rules. A one-action rule requires you to bring all of your foreclosure counts and claims and causes of action in the same lawsuit. And if you don't raise them at that time, you have waived them. California, for example, has a one-action rule. So if you have mixed collateral in California, you're likely running a judicial sale, not a non-judicial sale. And it also, if you're trying to sell operating businesses where it's hard to separate the personalty from the realty, and being able to sell them both to the same party to contain the economic unit matters. But this does.
And there's an important point to that too. On the flip side of the coin is Article 9 does provide that if you have real property that you're selling together with your personal property, you are authorized to proceed under the real property rules. So there's a specific provision, and the things that we're talking about today won't necessarily be applicable to those sales.
But if you do elect to just run and get a judgment against your borrower and without a foreclosure sale through the court at the time, the judicial lien that is issued as a result of getting a judgment against your borrower merges with your consensual lien upon the judgment, and the priority position is maintained and relates back to the perfection of your consensual lien. So if you go to execute through judicial process on the sale, you don't lose your place in line. And I would also mention that the UCC is pretty clear that the rights of to proceed judicially to reduce your claim to judgment and your right to sell your collateral are cumulative rights and need not be executed simultaneously unless you happen to be in a one-action rule state. All right, let's talk about non-judicial sales briefly. They are the most common. They're fast, they're cheap, and they give the most control to the lender. That's why most of these foreclosure sales run not through the court system. So in deciding whether you're going to go or which direction you're going to go in a UCC sale, we have to understand there's two kinds of UCC sales. There's a public sale and a private sale. And so the fork in the road here is, does the secured party want to own the collateral? Most lenders want to get paid back, but all of us have dealt with private equity firms and some other investor groups who come in and buy notes at a discount because it's their desire to loan to own, where their whole business model is to acquire ownership of the underlying collateral through a foreclosure sale process. So you need to understand, are there reasons why your client wants to own the property? And similarly, are there reasons why the client should not go in the chain of title on the property to become the owner? Typically, we see that as an environmental issue, and personal property can have environmental issues. I've dealt with a number of pieces of equipment over the years that have had environmental issues. The one that immediately jumps to mind is a paint system. It was a huge machine in a manufacturing facility that painted the end product, and it had probably 50 gallons of paint loaded into the machine, and paint was categorized as a hazardous waste. And so to sell that property, we had to deal with the concept of hazardous waste disposal. So there are reasons why the lender may not want to be in the chain of title on this. So
yeah. The other thing too on this slide is that there, it's like I tell my kids, there's a difference between wants and needs. But a lender may need to own the collateral because they may want to exercise their remedies in a more expeditious manner, and then ultimately determine how, if they can't find a buyer now, they're gonna dispose of it. So in that situation, a lender may be compelled to either own it directly or own it through, or to form a subsidiary and take title into the subsidiary.
And in some instances, it's a price protection issue. That if you went to a foreclosure sale today, the market just doesn't exist, and to get fair value, you may have to hold it for 12 to 24 months of marketing to find the buyer that the appraiser says will pay you the highest value for that property. So there are situations where the lender may need to become the owner. But if the secured party does want to be the owner of the collateral, there's really three different methods for the secured party to become the owner. The first is what is colloquially known as a strict foreclosure. Technically, the language of the UCC is a surrender in full or partial satisfaction of debt, and it can be as to part or all of the debt. The borrower may consent to such surrender of collateral for credit on the debt in full or in part in a writing signed after default. It's important to understand that you can't do this surrender and satisfaction of debt based on a pre-default writing. The borrower, the debtor has to sign that post-default. So a pre-default consent is not enforceable. The secured party may also send an unconditional proposal to accept the collateral in full or partial satisfaction to the borrower. And if the borrower does not object to it after 20 days, then a secured party may take ownership of that asset for the credit set forth in the unconditional proposal. But as with all rights under the UCC, we must be cognizant of the rights of junior interest holders, and such a notice of surrender and full or partial satisfaction of debt also goes to junior interest holders, and they have the right to object as well in the same 20-day timeline. And if the junior interest holder objects, you are going to have to sell it either through public or private sale process, and you won't be able to just take over the asset. Chris, anything?
If you go to, I mean, and the other, the issue, then we're going to get to the public sale versus private sale. And I think on your next slide, right, that the lender may acquire at a public sale, but can't and we'll talk about this, can't acquire at a private sale. If a lender ends up acquiring it as a part of a private sale, it's going to be deemed as a matter of law to have been a strict foreclosure, conducted as a strict foreclosure. And if you didn't jump through the hoops, then you've got problems. You've got remedies that you've given your debtor and the other obligors, and so you're probably by definition not going to have complied with those strict foreclosure requirements.
And Chris, I've jumped ahead. You just mentioned that a lender can acquire the asset at a public sale, and the lender can purchase by credit bid. So the normal way for lenders to become owners is to put it out to a public sale, show up, and be the bidder. Now, my experience is that most of those sales end up being just the lender. If it's not, say, a farm auction or a regular equipment auction run by an equipment liquidator, but if it's just a sale of the assets of a particular business, where you're trying to sell the intangibles as well as equipment and other items, oftentimes the lender is the only one that shows up to those sales. But the third method, of course, that the lender can acquire the asset is if the collateral is of a type that's customarily sold on a market, or there's a recognized market with a widely disseminated market price, spot price. And as long as the lender acquires it for that spot price on the day that they effectuate the sale, that sale does allow the lender to sell to themselves in a private disposition, but only of certain collateral. And usually you see this in the equity markets for publicly traded securities. It's not the only type of market that's out there, but it is the most common of the markets. Let's say the lender does not want to own the collateral. Again, the lender may still dispose of the collateral by public or private sale, and even the choice of whether it's a public sale or a private sale is governed by the concept of commercial reasonableness. To commence the public sale, you have to give a notice of the sale to the debtor of the time and place of the sale, and the notice has to be given to all creditors that have an interest in the collateral. Statutorily, the UCC says that they have to hold a perfected lien 10 days before the notice date of the asset. When looking for those perfected liens, you look not just at the UCC central filings, but it might be a type of collateral, a plane, a boat, a car that is perfected in a manner other than a UCC 1 filing, but you do have to give notice to those parties that have a perfected lien and hold that lien 10 days before the notice date. To know who those parties are, you have to run a search. The UCC is very clear. You must run the search not later than 20 days nor earlier than 30 days before you issue your notice. So if you have a sale that you're preparing, but for a variety of reasons, a forbearance agreement or otherwise, the sale is deferred, you are going to have to update your UCC searches. And the notice that you give has to be signed or authenticated. Uh, um, there are some exceptions that exist for perishable goods. If you've got lettuce rotting on the loading dock, the UCC is going to let you liquidate that on less than 10 days notice. And again, that would be a commercially reasonable choice rather than letting the produce rot. All right, contents of the sale notice. Again, these are checkbox, checklist type of items. They're contained in section 9613, but you have to identify the secured party. You must identify the debtor. You must identify the collateral to be sold. You must state the manner of intended disposition. You must state the time and place of the public sale. If it's not a public sale, you must state the date after which the sale will occur. And you must identify the right to request an accounting of the sale. There is a safe harbor form of notice that's contained in the UCC. And so this isn't rocket science. We don't have to reinvent the wheel. Using the standard form notice in most instances is perfectly appropriate. There are some instances for specialized collateral where you may have to do something more. And what immediately jumps to mind is LLC interests. LLC interests are, if you're going to sell them at a public sale, that is a public offering of a security, and additional hoops have to be jumped through to comply with the Securities and Exchange Act. There is an ability to issue private placement memorandums with regards to that, and some safe harbors for lenders to offer LLC or other securities for public sale. But there's substantial additional hoops beyond the form UCC notice that may have to be given under those circumstances. The private sale notice is virtually identical, so I'm not going to repeat that. But a private sale generally has to be on no less than 10 days notice. And so normally you see the notice say from and after 10 days after this notice, private sale may occur. Now, again, you have to look at the loan documents. The parties can agree to a longer time period. But again, the safe harbor minimum time period in the statute is 10 days. You do not actually have to have a sale in prospect. This is a gating issue to give you the right to sell and a date after which you can sell. And so it is not uncommon for lenders immediately after default to issue a notice of private sale to give them the optionality that they have to wait 10 days and then can go find a buyer. And no further notice need be given once you find that buyer. So that's a key concept there. However, if you think you're going to sell it by private sale, but ultimately can't find a buyer and you pivot and you say, I'm going to go back to a public sale, you're going to have to renotice because you have to give notice of the time and date of the public sale, both to the debtor and the other interest holders. Chris, anything on this before we move on?
Nope, I think we can move to the next slide.
What are the deliverables? And this is an interesting thing that I've encountered over the years. What we issue in a UCC sale is a secured party bill of sale. It is the lender that is the seller. And because of the UCC, they have the rights to sell. But the debtor won't be signing the bill of sale or any conveyance documents. Buyers love warranties and reps, but typically the minimum requirements of warranties and reps that a buyer typically will require is the secured party has to warrant they have a valid lien and there's a valid default under the documents, because those are the necessary elements under the statute to give the power of sale. And the effect of a secured party bill of sale is to give title free of the interest of the debtor, the secured party, and junior interest holders, provided you gave notice to the appropriate parties. Now,
it does not transfer title free and clear of prior secured parties, of priming secured parties.
Correct. It's free of your interest in anybody junior to you, but if there's someone higher up the food chain than you, you don't have the power to extinguish those liens. Now, depending on the assets and the manner you're selling them, this could look like any other sale transaction with an APA, disclosure schedules, closing statements, and it can have all sorts of warranties and reps. Just the key distinction is it's the secured party that's the seller. And the types of warranties the secured party is usually willing to give are not the same as an owner of the assets. And a note on that, and I know we've got a slide later on, but we're probably not going to get to all our slides here today. But under the UCC, a secured party gives all of the normal and customary warranties of title, quiet use and enjoyment, perhaps merchantability, like any other voluntary seller, unless they disclaim them. And it's very easy to disclaim them. There's safe harbor language in the UCC that says we disclaim all warranties. We typically make sure that all of our sales are as is, where is. And we have those disclaimers both in the notice of sale that we issue to the debtor and the junior parties, as well as all advertisements. Chris, any comment on that?
No, other than the fact that if you do have a prior, if there is a prior security interest with respect to that, and you've got a buyer that's really looking to get title, you may be in a situation where you have to bring in and have a separate agreement with your prior lien holder so that it can all be done at the same time, and you can transfer it, and the senior lien holder gives up its lien on the asset in exchange for some additional compensation.
Great. And we've just talked about the warranties. The specific statutory language on disclaimer of warranties is here. And this is the safe harbor language. There is no warranty relating to title, possession, quiet enjoyment, or the like in this disposition. Fairly basic, but there's a waterfall in the UCC of how you have to apply the sale proceeds. And of course, they start at the cost level, including the cost of repossession, storage, preparation for sale, cost of sale, including reasonable commissions. Then, of course, the secured party is the next in line after the costs, then the junior security interests that were known at the time of the sale. If after the sale, but before you distribute proceeds, you receive notice of another junior security interest, and that is an authenticated demand, then you have to pay that junior interest holder, even if you didn't know about them before the sale. And then at the end, there's a surplus to the debtor. Interestingly, there are certain types of surpluses that need not be provided to the debtor. If, for example, there's a non-cash proceed, you don't need to give that non-cash proceed surplus to the debtor unless the failure to do so would not be commercially reasonable. To give an example of what I think a not commercially reasonable surplus might be is if you sell a business, the assets of the business by secured party bill of sale, and in addition to the initial purchase price, there's some kind of earnout, and over time the earnout will pay the secured party more than their debt. It would seem to me that once the secured party has satisfied their debt, that surplus on that quote earnout would have to be paid over to the debtor, but only when received. That's an example of what I could see, because that's not necessarily a cash surplus at the time of the sale, because it's a contract right that may yield some benefit in the future. Additionally, certain types of collateral does not require payment of surplus at all. We've got the list there, and there's a theme there. It's the accounts, chattel paper, payment intangibles, promissory notes. Generally speaking, the foreclosure of that asset, you have the whole of the asset. So then if you go, it's then the owner of the party that has recovered it. So if you're the secured party and you've issued your account debtor notice, which is the foreclosure action on an account receivable, then you are now the owner of the account receivable. And if you end up realizing more value than the price you paid for the asset, you're apparently allowed to keep that under the UCC. So, all right. There's probably a lot more nuances on this, but we only get 30 to 45 minutes on the lunch hour. So we thought we'd take a break here and see if there's any questions that anybody has, and then call this one good. Let's see. So I think that's where we're at, and I don't see any questions in, and so we thank everybody for their time here today.